Hello everyone, I am Brianna. Welcome to today's in-depth training session. Usually when we talk about the law, we think of the tense courtroom battles and thick stacks of documents. But today I want to share a much more fascinating real-world case study, a classic behind-the-scenes drama in B2B international trade that I originally handled for a foreign corporation. This story will show you the fine line between the commercial risks and hidden legal traps, and how we navigate them with the utmost finesse. Imagine you are a CEO of a major corporation. You bring millions of dollars to Asia with the expectation of expanding your market. You find a local partner who seems absolutely perfect. But then things start to go off the rails, not because the market soared, but because of the very people you trusted the most. That is exactly what my client experienced. The representative of this corporation came to Vietnam and signed a memorandum of understanding, which is MOU, with a local company. And at the signing, the champagne was popped, firm handshakes were exchanged, and promises of a mega project were made. However, right after signing the MOU, when entering the formal contract negotiation phase, the Vietnamese side showed signs of wanting to renege on the initial agreement. They constantly delay failed to honor the initial terms and gave vague technical excuses to buy time. My client started to investigate, and the hidden twist was the reason to renege wasn't due to the market or their capacity, but because of the colleagues from the client's home country, and they had orchestrated this. It turned out that the Vietnamese company was secretly paying kickbacks to this insider to secure the project with prices and conditions favorable to them, bypassing standard business ethics. That insider, in return, constantly influenced the board of directors to force the parent company to make concessions to the Vietnamese partner. My client came to me in a state of extreme shock and confusion. They are a multinational corporation. They didn't want to make a fuss in the press to protect the corporation's reputation, and they wanted to resolve everything without causing waste. But they also asked me a hesitant question. Brianna, is commercial bribery the norm here? Are we forced to play by these hidden rules?
This is a disaster. We must apologize. We are deeply sorry for the oversight.
We are pleased we could resolve this amicably.
As a lawyer, when a client approaches me feeling helpless and terrified by hidden rules, my job isn't just to cite a dry legal provisions, but to hand them a protective shield and a shot to counter-attack. First, I had to clarify the boundary between commission costs and a crime. In Vietnam, the culture of referral fees does exist and is legal if transparently recorded in a corporate contract. However, the government is currently cracking down strictly on this when it turns into personal bribery. A Vietnamese company paying a partner's employee for personal gain is no longer business culture. It constitutes the gram of bribery in the non-state sector under the penal code. So the question is, why did the Vietnamese partner dare to play games right at the MOU stage so blatantly? Why didn't they wait until the contract was signed? The answer lies in the legal nature of an MOU. Most memorandums of understanding are non-binding. The Vietnamese partner and that insider knew this perfectly well because there were no contractual penalty clauses yet. They felt entitled to stone and alter the core terms to easily manipulate the project and the cash flow. They were testing the limits of the corporation's patience. Understanding the core of the issue, I started drawing a strategy to resolve it smoothly. My first and foremost important advice to the client was absolutely do not confront them personally or send threatening emails to the partner. The more you argue, the messier it gets, and you might easily alert the snake in the grass. Step aside and authorize your lawyer entirely for this communication process. We immediately launched our legal psychological leverage, drafting a legal demand letter sent directly via registered mail to the hands of the Vietnamese company's board of directors. And the content of this letter is an art form. It was designed to be highly professional and polite, but the strike was letter. We didn't even use the word lawsuit. Instead, we subtly reminded them of the anti-corruption law. We listed circumstantial evidence and gently mentioned the risks. If this situation continues, according to the global compliance regulations, we will be forced to report this misconduct directly to the client's headquarters overseas, as well as to the international auditing bodies overseeing the project. As a result, it always follows a classic script when the Vietnamese board of directors opened the letter, saw the involvement of the reputable law firm, and read about the criminal risks and danger of being put on an international blacklist, a risk that far outweighs the benefits of their backroom deals. They automatically panicked. Just 48 hours later, my client received an apologetic phone call, and the Vietnamese partner blamed it on a misunderstanding by junior staff, immediately withdrew their unreasonable demands, and obediently signed the formal contract exactly as initially agreed. They choose to back down in silence, thereby absolutely protecting our client's reputation, project, and cash flow without anyone having to file a lawsuit. That insider was subsequently quietly terminated by the parent corporation. Ladies and gentlemen, the B2B business world, especially in developing markets, always has its hidden corners. Having a sharp legal strategy is the best way to protect your company from unseen traps. Through this story, we learn that going to court isn't always the only solution. Sometimes a sophisticated move, a letter sent to the right person at the right time behind the scenes, brings the most complete and cost-effective victory. And I am Brianna, an attorney specializing in foreign direct investment. and commercial litigation in Vietnam. If your corporation is preparing to enter the Asian market, needs a solid legal shield or a sharp negotiation strategy for dispute resolution, please do not hesitate to contact me. Thank you for listening, and I wish you all brilliantly successful deals.